What is a fiduciary and what does it have to do with employment law? Fiduciary duties are not a substantial component of employment law in the same way they saturate other areas of law like securities law or trust law. However, they play an important role in specific issues in employment such as employee benefits and issues involving employee competition with the employer. Employees should understand the interplay between fiduciary duties under federal and Colorado law and their employment, both on behalf of the employer and employee. As this can involve complex legal issues, employees should talk to a Colorado employment lawyer for advice about specific situations. A fiduciary is a person or entity that holds a legal relationship of trust with another. Two common ways a person can become a fiduciary to another is by creating an agency relationship, and/or acting as the trustee of assets. What is a fiduciary duty? A fiduciary has fiduciary duties to the principal, for an agency relationship, or beneficiary, to a trustee. Fiduciary duties are primarily the duties to act in good faith and loyalty to the person owed those duties. Courts across the country deem fiduciary duties as the highest duties imposed upon a party under the law. In practice, courts do not always hold parties to the soaring rhetoric used to describe these duties, but at least they tell us they should. Most people think about fiduciary relationships with relationships between business and consumer such as a bank and its customers, or consumers and professionals such as lawyers or real estate agents. These are definitely fiduciary relationships under federal and Colorado law. The specific fiduciary duties owed differ under these relationships and sources of law. What is an employee's fiduciary duty to his or her employer? The employee-employer relationship is an agency relationship, which means the employee has a duty as the employer's agent as a fiduciary. An employee's fiduciary duty primarily revolves around the duty of loyalty. The duty of loyalty of an employee is not really a single duty but rather a collection of duties to the employer. Forgetting the issues of law for a moment, it makes common sense. No sane employer would hire an employee expecting the employee to use the position to harm the employer or compete against the employer. It does not mean the employee is at all times a slave to the employer. But the employee has a responsibility to deal fairly with the employer. Courts at times disagree with what exactly an employee's duty of loyalty entails. Often courts hold that an employee's duty of loyalty is commensurate with the employee's job duties and level of trust extended by the employer. Broadly, an employee's duty of loyalty to the employer can be broken up into two sub-duties: duty to exercise job with care, and duty not to compete with the employer. Duty of care by the employee. The duty to fulfill job duties with care is very simple. An employee is reasonably expected to perform the job duties with diligence and without intentionally causing waste or harm to the employer's business or property. That does not mean every time an employee underperforms the employee has breached a fiduciary duty to the employer. However, when an employee intentionally performs the job in a manner that is harmful to the employer, then the employer may have an argument for a breach. In practice, this often becomes an issue when an employee with access to valuable property willfully causes its destruction or loss of value. Most employers do not want to endure the time or cost to hire employment lawyers and pursue a lawsuit against an employee. Employees' duty not to compete with the employer. Fiduciary duty claims against employees are far more likely when the employee uses his or her position to compete against the employer. In fact, most breach of fiduciary duties in any fiduciary relationship arise from the fiduciary self-dealing. Employees' management positions, sales staff and employees responsible for developing new products or services are most likely to have access to resources that allow them to compete with the employer. Non-compete agreements. Although employers can pursue breaches of fiduciary duty claims in Colorado, an employer may decide that a lawsuit after the breach occurs is not a great remedy. After all, if an employee sends trade secrets like client lists or marketing research to a competing business, then it's effectively impossible to get that information back. Filing a lawsuit may take years to resolve with no guarantee that a jury will be more sympathetic to an employer than employee. To help solve this problem, many employers require employees with access to confidential information, client relationship, or high-level decision-making to sign non-compete agreements. Non-compete agreements, under employment law, are contracts between employer and employee that restrict the employee from competing against the employer by working for a competitor, sharing confidential trade secrets with competitors, self-dealing to the employer's detriment, or soliciting clients and employees to join a competing business. A non-compete agreement in many ways converts fiduciary duties from common law to contract and gives employers contractual remedies against the employee. A non-compete agreement can go farther than an employee's fiduciary duties by limiting the employee's ability to quit working for the employer and immediately go to work for a competitor. Colorado law and non-compete agreements. States differ in how broad they allow non-compete agreements to restrict an employee's ability to earn a living beyond the employer. Employers have an incentive to use non-compete agreements aggressively to retain employees. Employers may seek broad non-compete agreements as a poison pill to make it difficult for employees to leave and find work elsewhere. Colorado greatly limits the enforceability of non-compete agreements to prevent employer overreach. These limits are first statutory under Colorado Revised Statutes 82113, which makes all covenants not to compete void unless they meet an exception involving the sale of a business, protection of a trade secret, executive or managerial employees and their staff. Colorado, unlike some other states, does not allow a non-compete agreement to bind professionals like physicians to an employer even if the physician has trade secrets or acts in a managerial capacity over a hospital or clinic. Do employers have a fiduciary duty to employees? Generally, employers do not have fiduciary duties to employees. It is not a bilateral relationship. However, within a two-party relationship it is possible that the parties are separately fiduciaries in different roles to the other. The most common way an employer acts as a fiduciary to employees is when it operates retirement benefits for the employee. This requires that the employers act in the interests of employees and exercise care with the assets. The Employee Retirement Income Security Act of 1974, ERISA, governs most private employee retirement plans and establishes statutory fiduciary duties that limit the employer's ability to use the plan or plan assets to its own financial gain.